1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်435ဦးလှတင်ဦးမြကြိုင် appellant vs ဦးမြကြိုင်ဦးလှတင် respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးကျော်ဆန်းဦး and ဦးချစ် judges ဦးလှတင်ဦးမြကြိုင် appellant vs ဦးမြကြိုင်ဦးလှတင် respondent suit for recovery of damages auction sale of the property at the instance of State Agricultural Marketing Board Code of Civil Procedure Section 47 whether the question of damages arise out of the decree in execution whether a separate suit is maintainable U La Tin claimed damages against U Mya Jai for making use of the property that is the rice mill sold by public auction and for the loss incurred on account of the dismantling of the dunny roof from the rice godown. Hell, there was all question arising in Section 47 of the Code of Civil Procedure mean all connected questions which could properly arise or could properly have been raised in execution proceeding between the parties to the suit. It is considered that the question of damages is not merely incidental. It directly arises out of the decree in execution. The question of damages arising between U La Tin and U Mya Jai, who are parties to the recovery proceeding in which the decree was passed and relating to the execution is to be determined by the Revenue Court executing the decree and not by a separate suit, as a separate suit is not maintainable under Section 47 of the Code of Civil Procedure. Bashon Chanton Ang Vice Chambo for the respondent. Bashon Chanton Ang Vice Chambo for the appellant. Ujo San U Judge in Civil Regular Suit number 2 of 1962 of the District Court of Pyabong, U La Tin claim that 16,744.50 as damages against U Mya Jai as per particulars set out in Schedule Kaji and Kagwe attached to the plain which are not in dispute. U La Tin own jet 130,000 to the State Agricultural Marketing Board and in default of payment his Tatekong rice mill, machineries, engines, boiler, husk and boiler shed, paddy godown and engine shed standing on 3.78 acres of land in Chailat Town given as security for the loan were auctioned in revenue proceeding numbered 4R D of 1958-1959 of the Township Office of Chailat on 25 November 1959 and U Mya Jai purchased them for jet 101,000 and obtained possession on 10 February 1960. It was alleged in the plain that the mill site was not included, so we give an opportunity to the advocate for U La Tin to show us at least a copy of the original security bond or mortgage deed, which is said to be still in the main office of the SAMB in Rangoon for verification, but we were not successful. We entertained doubts if the boat would at all accept the mill and its appurtenances without its side, as a rice mill cannot hang in the air. It was also alleged that the auction purchaser, U Mya Jai, forcibly took possession of the mill site and rice go down. U La Tin alleged that without ascertaining the exact amount due by him to the boat, the public auction of the aforesaid property should not have been held by way of execution for default of his payment of the loan. We may note here that under Section 13(3) of the Union of Burma Agricultural Marketing Board Act 1950, Act number 57 of 1950, as substituted by Section 3 of the Union of Burma Agricultural Marketing Board Amendment Act 1956, Act number 3 of 1956, all debts or advance with interest, if any, and costs, if any, are to be recovered from the debtors or sureties as if they were areas of revenue. Under Section 45 of the Land and Revenue Act, an area may be realized as if it were the amount of a degree for money passed against the defaulter in favor of any revenue officer, and proceeding with a view to the realization of such areas may be instituted by such officer before any other revenue officer, who may exercise all the powers conferred on and shall conform to all rules of procedure prescribed for a court executing a decree by the Code of Civil Procedure. It will be seen from the order of the Deputy Commissioner of Pyabong, date 20 April 1960, setting aside the first auction sale and confirmation due to some defects in the revenue proceeding, that direction was given to the township officer to conduct the sale under Rule 95 of the Land and Revenue Act as immovable property. The sale was made absolute under Order 21, Rule 94 of the Code of Civil Procedure, which also relates to immovable property. See Exhibit Kangwe in MSMP SKR Fan First Assistant Custodian of Movable Property, Tangu, and 1. Our late Supreme Court held that boiler, engine, and machinery of a rice mill being attached to the Act were immovable property. Under Section 229 of the General Clause Act, immovable property includes land and things attached to the Act. In the instant case, engine, machinery, etc. were attached to the mill site. Hence, the property sold by public auction was nothing but immovable property, including the mill site, which is inseparable from the rest. In Civil Miscellaneous Application numbered 78 of 1960 of the late Supreme Court, U La Tin succeeded in setting aside the auction sale by his writ of certiorari on 8 September 1960, and accordingly U Mya Jai reconveiled the entire mill site, စက်မြေတစ်ခုလုံးကို alleged to have been taken forcibly to U La Tin on 26 October 1960 and got his refund of the purchase money. U Latin himself admitted and accepted that the auction sale was in execution of the decree obtained by the SAMB against him in his own application date 19 October 1960 in the revenue proceeding to reconvey the property to him in view of the order of the Supreme Court setting aside the auction sale. There is therefore no substance in the contention and argument of his advocate that it was not a decree in the application signed by him and his then advocate U.A. Mao. He used the word "sari" at not less than 7 places and state လျှောက်ထားသူပိုင်းပစ္စည်းများအပေါ်၌ဇာရီပြုလုပ်သည့်အမိန့်ကိုအမှုခေါ်စာချွန်တော်အမိန့်ဖြင့်ပယ်ဖျက်လိုက်သည် U Latin alleged that as U Myagjai had made use of the property sold by public auction from 10 February 1960 to 26 October 1960, he had lost to the extent of Jet 15,155 and Jet 1,589.50, being the lost income on account of the dismantling of the Dani roof from the rice godown by U Myagjai, making a total amount of Jet 16,744.50 as shown in the schedule Kaji and Kagwe attached to the plane. U Myagjai, in his written statement, stated that the sale was conducted according to the procedure laid down for immovable properties under Section 46 of the Land and Revenue Act, and there was no objection to the dismantling of the roof by U Latin. He denied that he took forcibly and contended that the mill site was also included in the sale as part of the mill. He stated that the sale was set aside by the late Supreme Court not due to the fault of the parties, but for the fault of the revenue officer, who should be sued. He explained that the reason for pulling down the old Dani roof was for the purpose of insurance, as the godown was close to the rice mill, which was indisputably insured afresh for Jet 150,000 on a premium of Jet 2,820, Exhibit 3. On this pleading, the trial court framed 6 issues, and after hearing, answer only issue number 4, which runs for whether plaintiff is entitled to claim for damages from the defendant for the loss to the amount of Jet 50,155 and to the amount of Jet 1,589.50, or whether if any claim for damages is to be made, it should be made against the officer concerned who ordered the suit properties to be sold in public auction by dismissing the suit with cause holding that the plaintiff was not entitled to claim for damages in tort, inasmuch as the late Supreme Court had held in its civil miscellaneous application number 78 of 1960, supra, that the auction sale was illegal as it was held without due inquiry as to the accurate amounts due by U Latin to the board. Agreeing with the late Supreme Court, the trial court held that U Myagjai obtained possession as given lawfully by the township officer of cited, who conducted the sale, and therefore U La Tin lost possession of the property not because of the fault of the parties, but mainly because of the fault of the township officer of cited. The court was of the opinion that the dismantling of the tin roof was to prevent risk of fire and to procure fire insurance for the benefit of the rice mill and its appurtenance. It held U Mya Chai was not in wrongful possession of the properties, making himself liable for damages. Being dissatisfied with the judgment and decree, U La Tin preferred an appeal, being civil first appeal number 12 of 1963 of this court, stating that U Mya Chai purchased the property at his own risk and was liable for damages inasmuch as the Supreme Court had held that the revenue auction sale was void altogether. The bench of this court, consisting of Soba Tin and U Thon Tin judges, set aside the judgment and decree and remanded the suit under Order 41, Rule 23 of the Code of Civil Procedure, with the direction to decide the suit whether U Mya Chai was liable to pay the amount sued, taking into consideration the fact that the sum of debt 101,000 being the purchase money had been paid into court by him during the period in question, viz. 10 February 1960 to 26 October 1960. He was in possession of the property and not by basing the decision on the lot of torts. In this connection, we may note that U La Tin has filed an application date 10 December 1966 under Section 13 of the Court Fees Act for the refund of the court fees paid on his appeal, Civil First Appeal number 12 of 1963, on account of the remand of the suit for second decision by the trial court. This point was also heard by us together with Civil First Appeal number 43 of 1964, filed by U Mya Chai, and his counsel has addressed to us in the course of the argument that he has no objection to the refund. We therefore order that U La Tin be granted a certificate authorizing him to receive back from the collector the full amount of fee paid on the memorandum of appeal. The trial court reheard the arguments without taking further evidence and decreed the suit on 12 December 1963, with course in a very short judgment holding that the revenue sale having been quashed by the late Supreme Court, the possession of the property without the mill site and a rice go down by U Mya Chai being illegal. He was a trespasser and as such liable for damages claimed by U La Tin. It said the removal of the tin roof was for his U Mya Chai own safety only, and that as regards the deposit of debt 101,000 with the government as auction purchase money by U Mya Chai till the redelivery of the property to U La Tin, the sale being illegal, no claim of any kind could be made against U La Tin. Now it was U Mya Chai's turn to come up on appeal, and he filed this civil first appeal number 43 of 1964 against the judgment and decree, date 12 December 1963, stating that the judgment of the district judge, Ugoji, who never went into the merits of the suit and gave cogent reasons for his conclusion, is not a judgment at all. With the leave of the court, the following additional legal grounds were raised by Umya Jai, the appellant through his advocate, for that the learned trial judge erred in law in not holding that the respondent's suit was not maintainable and that he had no jurisdiction to entertain the suit in view of Section 47, read with Section 144, Civil Procedure Code. The counsel for the appellant Umya Jai, in the course of his argument before us, submitted he would not press his point raised under Section 144 of the Code of Civil Procedure. Being a question of law, we rule this additional ground could be taken up in this appeal, even though it was not raised in the trial court. In Haji Abdul Shakur Khan vs. the Burma Publisher Limited 2, it was held that a question of law raised for the first time in court of last resort would receive consideration only if it was based upon facts admitted beyond controversy. In the instant case, the facts are not in dispute at all. The bench, consisting of Uton Ting Judge and one of us, Uche Judge, in its order date 18 April 1966, accepting the following issue submitted by the parties by consent, remanded the suit for the second time to the trial court under Order 41, Rule 25 of the Code of Civil Procedure for trial, directing it to take the additional evidence required and to submit the same with its finding thereon and the reason therefore. Issue 1. တရားခံသည်ကြိုက်လက်မျိုးပိုင်ကထုတ်လိုက်သောအချင်းဆန်ဆက်အဆောက်အဦးနှင့်နေရာတို့ကိုလေလံတင်ရောင်းချသည့်အခွန်တော်ရယူမှုတွင်သဘောရိုးဖြင့်လေလံဆွဲဝယ်ယူသူဖြစ်ပါသလား။ကာကြီးဖြစ်ပါကတရားလိုကတရားခံအားဆွဲဆိုထားသောအဆိုပါအချက်များအရာတရားဆွဲဆိုနိုင်ပါသလား။ခါခွေမဖြစ်ပါကတရားလိုသည်တရားခံတဦးအပေါ်အဆိုပါလေလံတင်ရောင်းသည့်ဆန်ဆက်နှင့်နေရာနှင့်ပတ်သက်၍ရော်ကြေးရလိုမှုတရားစွဲဆိုနိုင်ပါသလား။နှင့်ရခင်တရားလွှတ်တော်ချုပ်ကအချင်းဖြစ်ဆန်ဆက်နှင့်နေရာများကိုကြိုက်လက်မျိုးပိုင်ကမှားယွင်းပြီးလေလံတင်ရောင်းချခဲ့ခြင်းဖြစ်သည်ဟုဆုံးဖြတ်ထားချက်ရှိသဖြင့်၎င်းလေလံတွင်တရားခံကဝယ်ယူသူတဦးဖြစ်သည့်အလျောက်တရားလိုကတောင်းဆိုသောရော်ကြေးများကိုတရားခံကကြားခံရမည်လောသို့ဒီမဟုတ်အခွန်သက်ဆိုင်ရာအရာရှိမျိုးပိုင်ကကြားခံရမည်လော3တရားခံဦးမြကြိုင်သည်အဆိုလွှာတွင်ဖော်ပြပါစက်ပစ္စည်းများကိုလက်ရှိထား၍အသုံးပြုခဲ့သည့်ရက်လအတွက်တရားလိုဦးလှတင်အားဆွဲဆိုထားသည့်အတိုင်းရော်ကြေးကိုပေးထိုက်ပါသလားပေးထိုက်ပါကတရားလိုဦးလှတင်သည်တရားခံထံမှရော်ကြေးမည်မျှရထိုက်ပါမည်နီ၄တရားခံဦးမြကြိုင်သည်ကျပ်ငွေ3,100,000ကိုရုံးတော်သို့အဆိုပါရက်လအတွင်းတင်ထားရခြင်းကိုထည့်သွင်းစဉ်းစားသင့်ပါသလားစဉ်းစားသင့်ပါက၎င်း၏အတွက်မည်ကဲ့သို့စဉ်းစားထိုက်ပါသနည်းငါတရားခံဦးမြကြိုင်သည်ကျပ်ငွေ3,100,000ကိုရုံးတော်သို့အဆိုပါရက်လအတွင်းတင်ထားရသည့်အတွက်တစုံတရာသက်သာခွင့်ရထိုက်ပါသလားရထိုက်ပါက မည်သည့်သက်သာခွင့်မျိုးကိုရထိုက်ပါသနည်း6တရားလိုသည်မည်သည့်အခြားသက်သာခွင့်ရထိုက်ပါသနည်း The district judge U Nyon took fresh evidence of the parties and their additional witnesses U Aung Thein and U Ba Thon and on 23 September 1966 give his finding that though U Mya Jai purchased the property at the auction sale bona fide, he alone could be sued for damages for the loss suffered by U La Tin when out of possession amounting jet 15,430 made up of jet 15,155 as in Schedule Kaji of the plane and jet 275 out of jet 1,589.50 claim in Schedule Kagwe without taking into consideration the fact that U Mya Jai had to deposit jet 101,000 with the government after his purchase. U La Tin in his objection date 12 December 1966 under Order 41 Rule 26 submitted that he was entitled to the full amount he claimed in Schedule Kagwe and not the bare amount of jet 275. He prayed for a degree for the amount sued. U Mya Jai, on the other hand, contended in his objection date 27 February 1967 that under Section 13(3) of the Union of Burma Agricultural Marketing Board Act 1950 at 57 of 1950 as substituted by Section 3 of the Union of Burma Agricultural Marketing Board Amendment Act 1956 at 3 of 1956 read with Section 45 of the Land and Revenue Act and Section 47 of the Code of Civil Procedure. The suit was not maintainable at all from the very beginning. He stated that though the district judge held that he purchased the property bona fide, he failed to consider the legal point involved. He emphasized that since the suit arose out of execution of a decree, Section 47 of the Code of Civil Procedure apply and the claims, if any, should be determined by the Revenue Court executing the decree and not by a separate suit for damages. We are thus faced with the difficult question of law. He further stated that the answer given by the district judge to the other issue were based on the aforesaid primary point raised in his objection, so they could not be upheld. The section provides a cheap and expeditious procedure for the trial of question without recourse to a separate suit. Under this section, all questions arising between the parties to the suit, that is, recovery proceeding under Section 13(3) of the Union of Burma Agricultural Marketing Board Act 1950 as substituted by Section 3 of Act 3 of 1956 for the loan read with Section 45 of the Land and Revenue Act, in which the decree was passed and relating to the execution of the said decree shall be determined only by the executing court. It cannot be denied with any force that there was decree against U La Tin obtained by the State Agricultural Marketing Board, and in execution of the said decree, the property was ordered to be sold by public auction and U Mya Jai bought it. but the order for sale by public auction was nullified by the late Supreme Court. The sale was set aside, but execution was never closed. The decree still remains alive. Hence, the question as to the claim and liability for the damages in the suit relates to the execution of the decree, and this question should be determined by the Revenue Court, which is in season of the execution of the decree, but this question of damages never arose between the parties in the proceeding in which the decree was passed, that is, between the State Agricultural Marketing Board and U La Tin. It is a question between U La Tin and U Mya Jai only. The State Agricultural Marketing Board was the decree holder and U La Tin was the judgment debtor. U Mya Jai was only a stranger auction purchaser. There was a conflict of authorities on the question for many years whether a stranger auction purchaser was a party to the suit or not. In India, the point is now settled in view of the substitution of the was and the purchaser at the sea in execution of the decree. In the explanation to Section 47 of the Code of Civil Procedure, between the was, dismissed and are, and the deletion of the word and between the was, dismissed and a, our law, however, remains the same, probably because we have no direct authorities at all on the point. We, however, express our view that we are in favor of the law that a stranger purchaser in execution sale is a party under Section 47 of the Code of Civil Procedure as substituted in India. Mullah, in his monumental work on the Code of Civil Procedure, while discussing this point under Section 47 at page 167, volume 1, 12th edition, also observed, it is high time that the section was amended and the conflict set at rest. Hence, the Code of Civil Procedure Amendment Act of 1956 in India, the conflict of authorities was recognized in Burma so long ago as 1929, as it will be seen in J.A. Martin vs. S.M. Hashim and others 3. It is left to the authority concerned to amend the law in Burma as well to avoid conflict of authorities. This is the only important but rather a difficult point raised for decision in the arguments before us. The was all question arising in Section 47 of the Code of Civil Procedure mean all connected question which could properly arise or could properly have been raised in execution proceeding between the parties to the suit. We consider that the question of damages is not mere incidental. It directly arose out of the decree in execution. This question would not have arisen if there was no decree against U La Tin and sale of the property in execution of that decree. Having stated our reason, we now came to the conclusion that the question of damage arising between U La Tin and U Mya Jai, who are parties to the recovery proceeding in which the decree was passed and relating to the execution is to be determined by the Revenue Court executing the decree and not by a separate suit, or in other words, we hold the suit is not maintainable under Section 47 of the Code of Civil Procedure. In the result, the judgment and decree, date the 12th December 1963, passed by the District Judge of Pyabong, U Guoji, are set aside and the suit is dismissed with courts throughout